Hello, all, and welcome to the Law and Other Things podcast series. Today, we are delighted to have with us two very special guests, Professor Tarunabh Khaitan, who is one of the most widely respected scholars of constitutional law. He is currently Professor, Chair of Public Law at London School of Economics. Earlier, he taught at Oxford. His writings has been cited at Indian Supreme Court, the European Court of Human Rights, the Canadian Supreme Court, among others. We also have with us Surbhi Karwa, who is a PhD candidate at University of Sydney. An Oxford graduate, she is frequent contributor to academic journals, blogs, and media. She has been awarded the Latin Prize Fellowship at LSE and the Bonnevaro Human Rights Fellowship at Oxford. Glad to have you here both.
Thank you. Thank you for having us.
Thank you for
First of
having
all,
us.
I would like to congratulate you on your wonderful book called Hum Bharat Ke Log. The book is a remarkable effort to take the Indian constitution beyond the legal and academic circles into the public domain, especially by the use of the language Hindi. Before moving on, I would like to briefly introduce the book for our listeners. In the last few years, we often hear that the Indian constitution is in danger. This book does not take that claim for granted. Instead, it asks that what are the core ideals of the constitutions and what kind of institution exists to protect it. And more importantly, it gives us the tool that how can people themselves safeguard the constitution. Through the help of these 9 essays, the book takes complex constitutional issues like federalism, rule of law, democracy, and makes them accessible to a wide audience with no legal background. As a reader, what impressed me the most was the balance which you strike with the unprecedented accessibility in these just 110 pages. The book does not compromise on the academic rigor or the nuance and tensions which are essential for analyzing constitutional issues in India. This, I believe, greatly enhances its educational value. With that, let me turn to some questions. In keeping with the spirit of the book, I have framed them in simple and open way so that even listeners from non-legal backgrounds can follow and engage with our conversation. I would like to begin with Professor Tarunabh. Much of the scholarship on the Indian Constitution remains in English and is largely confined to legal or academic circles. This book is written in Hindi in a style that is both accessible and engaging. So could you share that what inspired you to take this step, and was it mainly to reach Hindi readers left outside the constitutional conversation, or was there a deeper motivation behind the choice of language?
Well, thanks for having us, Jitendra, and thank you for that close reading of the book and that very kind introduction. It's a delight to be back on the Law and Other Things blog, which I've been involved in a long time ago, and then since. The book came out of conversations that Surbhi and I started having soon after the 2020 anti-CA protest. 2019 was it? I mean, just before the pandemic. When we noticed how the preamble of the Constitution was being read communally by communally, I mean, with a lot of people together, not in a sectarian manner, but in mass protests across the country. And then we discovered the popular use of the Constitution in the Patalgadi movement in Adivasi villages in Jharkhand and MP. We heard about its use by Nalsar in Gujarat for land rights claims. So the Constitution obviously permeates Indian political discourse in very deep ways, in ways that is not true of every country. The Constitution in India is not just in its courts, it's clearly on the streets. And yet, when you ask non-lawyers what the Constitution is about, there's some things that are well understood. There's an appreciation that it has an inclusive, pluralistic, secular, egalitarian character. There is an appreciation that Dr. Ambedkar was a key architect of this Constitution, so his ideological imprint is to be found within it. And there's an association of the Constitution with the reservation policy. And maybe there's some appreciation of rights because those are the types of things the media tends to report, Supreme Court cases or High Court cases on rights claims. So beyond that, we thought there was a dearth of knowledge more generally amongst the non-legal audience. And this was true in all Indian languages. So even the English literature that you have pointed out is very technical and is written for lawyers by lawyers, right? But we toyed with the idea of whether we should do this in English or Hindi. It actually started with a video interview series that Surbhi and I and Rajesh Ranjan did for first for The Wire and then for Live Law, and then we thought we should write it out. And the choice of Hindi, basically, so finally to come to your question, was basically because if you're trying to write a book for the non-legal audience, then the most value for our time in terms of who we will reach was obviously Hindi, because the number of Hindi speakers in India is much higher than people conversant in English, and also there is some material available in English. There's nothing in Hindi. It helped that Hindi was the common language that we all were to different degrees of fluency conversant in, at least for the podcast series. So those were the reasons for choosing Hindi. But now, obviously, we're having people reaching out to us. We're in serious conversation with one publisher about an English translation of, I don't think there are many books written first in Hindi in law, which are then translated into English, but this might be the first, I don't know. So we think we're in conversations about that. And then others have reached out about potential translations in other Indian languages as well. It'll have to be done by other people, not us, because we don't have the ability. But I think that's so have I captured the main motivations?
Yeah, I think so. I mean, I'm in complete agreement and don't really have anything to add, that rights get quite a lot of attention, but we don't know about other institutions. Despite so much interest in politics. I mean, if you look at the voting percentage in India as compared to some of the other democracies, it's very high. So the people are engaged, but sort of normative framework, what constitution is saying is not there. So sort of the idea of writing in Hindi, of course, was actually not Hindi, Hindustani. So we've tried making sure that not too many Sanskritized words are there, because if you look at legal Hindi also, it's quite difficult. People who speak Hindi would also not be able to keep up with legal Hindi. And I've given this example at other places also. Contract, for example, is called Samvida. Even Hindi speakers wouldn't be able to keep up with that. So we've tried keeping it Hindustani. Perhaps in our ideas of our national movement, a mixture of Urdu, Hindi words rather than any sort of extreme. But yeah, Tarun has covered everything.
Yeah. So thank you. That's actually a really great perspective. I have a related question to the book and the introduction. So you have selected 9 major themes, from preamble to federalism to democracy. Can you elaborate on what was the criteria while selecting these 9 themes? Were they chosen because they were the most contested areas in Indian constitutions, or because they best illustrate the constitutional culture that you wanted to highlight to non-legal audience? And did you feel that limiting yourself to 9 essays, there is something which has been left out which you would like to cover?
I think it happened a lot more organically, because we were doing it as a conversation, a monthly conversation, first with Wire and then with Live Law. So it was a lot organic to think that what are the issues that get talked about, but there is dearth of material. So that's how we did an episode on democracy. Then we realized that, okay, we have explained some theoretical ideas about democracy, but what does that mean in terms of electoral system? And what does the impact of first past the post system have about ideas of democracy? What does it relate? How does it relate to majoritarianism? So based on as we were going, we sort of created these 9 themes. And of course, there are some things that have been left out. As Tarun was saying, that we are in conversation for an English version also. So we don't have a rights chapter that we have added, because at that time we had thought that rights are talked about a lot. So maybe we need to talk about other institutions. But definitely in the next, if we go ahead with the English version, there would be a chapter on rights. And some of the things have also we have not gotten a chance to explain them in detail. Sometimes also there's been a struggle with technical words in Hindi. But for example, in the federalism chapter, we can discuss more about finances and federalism. That bit we haven't covered. As far as the 9 themes are concerned, the book is divided sort of in 3 parts. The first part is about the preamble and the drafting process, that how was it created, what was happening in Constituent Assembly. The second part is about these concepts: rule of law, liberalism, democracy. The reason we chose to explain these words is that, again, that we hear those words very rhetorically. We see both under and overuse of these words, but we don't really know that what does rule of law mean. When we say that somebody has been kept in jail for 5 years, it's violation of rule of law, but what does that mean? So to explain those common terms, that was part 2, and part 3 is about citizenship provision, which was the immediate concern with which we started this book. So that explains citizenship. So that's how we planned sort of all of this. Tarun, if you would like to add on anything.
Yeah, just 2 things. First is that the Indian Constitution exists in 2 different registers, right? And this is true of every long constitution, but it's particularly true of the Indian Constitution. There's a higher aspirational, lofty moral register, which is something we find mainly in the preamble, not just in the preamble. We also see it embedded in multiple provisions on rights, on institutions. So even when secularism was not mentioned in the preamble, you could see it embedded in multiple parts of the Constitution, for example. This is the universalist, humanist, and Indian values that the framers wanted to realize in the country. And then there is a much more granular, you can call it lower in quotes, register of the Constitution. This is a more pragmatic, political, compromise-driven, consensus-seeking register of the Constitution, where things are imperfect, right? Because compromise and consensus lead to imperfections, right? There are things we don't like, things like the office of the governance, things like permission for preventive detention, right? And obviously some of these things are explained because of the immediate aftermath of the partition violence that the Constitution is being written in. But the framers understood this distinction, and I would like to read our Constitution as a dynamic document. And part of the explanation of the relative ease of amendability of the Constitution, is the framers' hope that the granular nuts and bolts, pragmatic, practical register will continuously be improved to bridge the gap between it and the higher aspirational moral register. So I think that's one way to think about the book as well, that while the organization of the chapters, headings are in the higher register, we're not hagiographic about the Constitution, right? We are not uncritical about its granular register. We acknowledge that this Constitution needs improvement, that it has flaws, right? So that's one way to read the book. The second thing I would say is that this wasn't an easy book to write, right? Hindi, although Surbhi and I are Hindi speakers, it's not a natural language of writing legal material, right? It's been tough. And in choices about how to be intelligible using colloquial words rather than, bombastic words, all of that has been very difficult. So comprehensiveness was not the goal, right? We did not want to cover everything. And I still hope that this is first of many, many books that will be written by other people, right? We are not, my Hindi is definitely very clunky, and the book has grammar issues, it has copy editing issues, right? So it's not a perfect book, a bit like our Constitution, right? It's work in progress, but others need to take it forward.
Thank you so much for your response. That is really insightful. You have argued in your book that constitution endure when they are not based on winners take at all approach, but based on inclusive bargains, giving every group a hope that they will get power someday. This inclusivity is reflected in the use of the phrase Hum Bharat Ke Log in the preamble itself. So, can you explain to our audience how this inclusive foundation of our constitution has helped us endure moments like emergency?
Um, I think the importance of inclusion um, for the Constitution was a lesson the framers learned the hard way. The the Muslim League walking out and partition underscored for them what can happen if the demands of a group, whether you agree with them or not, are completely rejected, right? And we know that Muslim League had the red line in the cabinet mission plan, which Nehru rejected, and or at least refused to bind the Constituent Assembly by. Right? He said that the Constituent Assembly is a sovereign body, and he was right in his place. It was a sovereign body, but for Muslim League, it sought those guarantees of implementing the confederal uh, framework as a red line that the Constituent Assembly will be bound by. Having learned that lesson, the Assembly was extremely careful not to have any other walkouts because they had seen what happens. Right? And, Nehru and others bent over backwards to try to convince the socialists who had boycotted the Assembly to join it, and partially succeeded. Some socialists did join. The Communist Party did not. And the Communist Party was met with the full force of the state. Right? There was a very violent repression of the communists, who incidentally do come around and fight elections under the Constitution that they had boycotted the framing of. But anyway, so I think that was a hard-learned lesson, and I think it worked. I believe all but one members of the Assembly signed it. And their members, from like the Hindu nationalist members were saying, I don't like this constitution, but I'm willing to live with it because they've put in provisions like the cow slaughter prohibition directive and other such things, right? So members, even if they're doing it holding their noses, they do end up signing it. Right? And that is what was extremely important. The emergency obviously was a huge setback to the constitutional frame. I think a partial restoration did happen with the 44th Amendment, and the short-lived Janata government did do a lot to restore constitutional democracy. But some of the damage that Indira Gandhi's time had done to the framework obviously remains with us today.
I think just to add on to that, if we talk of the other comparative research on this, the idea that you have to bring everybody together, give something to everyone, probably not everyone would be happy. And if you look at the debates around November 1949 and right before, mostly the final statements from everybody are in November 1949 debates. Just by the way, the debates, all of them are available online. So if people like, they should just spend some time reading them as well. You see everybody who's giving a statement is mixture of that, oh, this is not perfect, that is not perfect. So they thought of it as very much also a work in progress. So you would see also some of the chapters were deferred. So language, for example, was deferred for future parliaments to sort of figure it out. So that idea that let's bring everybody together as much as we can, and some groups, everybody would be little unhappy, that was pretty much there. And if you look at the comparative work later, we mentioned this in book that Tom Ginsburg and a couple of other authors have this idea of how do constitutions endure, how long do they last, and the average age. And they've analyzed constitutions from, like, I think from beginning from the US and even before that. Consensus, bringing everybody together is one of the reasons why constitutions continue. And it might also be a red herring for constitutions that are being drafted today, that if you exclude one group entirely, it might not work. Just in terms of emergency, I just wanted this, not something that we've talked about a lot in the book, but I think what also made constitution endure during that time was the elections after that people saw that emergency was declared, and then the government of Indira Gandhi was thrown out of power because they recognized that this is excess, this is getting too much. Probably the challenge as we go today in current time is to sort of identify those patterns, even if they are not named emergency as such, to identify those patterns and sort of not be gaslit. So to say that, to identify that what is happening would perhaps be, that's what differentiates today's time from Indira Gandhi's emergency as well, that with the sort of disinformation that is there on social media, role of people, because Indira Gandhi did lose election because of imposing emergency. What are the patterns today is something that we need to think about.
I just add a minor point of emphasis there in something Surbhi said, which is that a consensus document is one that nobody loves, or everybody hates, right? And that's quite an important feature of a consensus, that nobody is completely happy with it, and that is a good thing. Right, it's a sign that that everybody has had to give something, and everybody has had to make compromises. So I think a constitution that is celebrated by only one group, one community, or one section, one political ideology is probably not a great constitution. You said, the opening words, "We the people of India." If you look at the Irish constitution, for example, it starts with an invocation of the Holy Trinity. It's a very Christian constitution in its orientation, and that, Ireland in the 1930s was an overwhelmingly Christian country. But we did not do that, in part because we did not have that kind of homogeneity that would enable you to do that without rancor and without upset.
Sorry, can I just add, when Tarun was speaking of Irish constitution and beginning words, it just reminded me that in the Constituent Assembly, there were proposals, one, to begin the preamble in the name of God, and also to begin in the name of Gandhi, that, you should pay homage to Gandhi, that he's done a lot. And both of these ideas were rejected, that the idea of starting in the name of the God was rejected. And I think that is something remarkable about our constitution, that it says that, what about the people who do not worship any God? So thinking about atheists who do not want to believe in God, that sort of inclusion was also thought out, and that was removed. That proposal didn't pass. And similarly, so many of the amendments that people had suggested overwhelmingly had a suggestion that put Gandhi's name in the preamble, and that was not done. Again, because there were people who were in huge disagreements with Gandhi, and both of those words, despite Gandhi was quite popular, he was not member of the Constituent Assembly, but he was very much there in the assembly. If you look at the 15, or not 15, but all the women members, all of them almost were Gandhian, and had been involved in Gandhi's reconstruction work and all of that. But even then, Gandhi's name was not included in the preamble. That proposal didn't pass. So it was they wanted to make sure that it's not about one person.
Thank you so much for that response. Your response actually leads me to my next question, which is related to your first theme on preamble. You discuss how the terms secular and socialist were added by 42nd Amendment during the emergency period. Today, these words were again contested. How do you see that these words were original commitment, binding, and flowing from the original text of the Constitution, and not merely as amendment done later?
So, should I go ahead? Yeah, I think that we hear that public discourse a lot, that secularism and socialism were the words that were not there in the Constitution. They were added later in 42nd Amendment. And we try to explain that in the book, that what does secularism mean? It's a massively debated topic in political theory, in constitutional theory. But if you look at from the perspective of constitutional design, secularism basically means three things. That one, the state would not have one religion as state religion. Second, that people would enjoy freedom of religion. And third, that there will not be any discrimination on the basis of religion. And all these three things are there in the Constitution that was passed in 1940. India, nowhere in the Constitution we give any religion as state religion. Article 15 states religion as ground for non-discrimination. And if you look at Article 29, 30, you have freedom of religion. So to say that secularism was sort of the idea that Indira Gandhi imposed is sort of slightly unfair, because the elements of secularism were pretty much there in the 1950 document. And the word perhaps was avoided because there was just so much confusion about what exactly does the word mean.
Just to pick up where Surbhi left, first on secularism itself, we should also note that one of the worries was that secularism in the West also meant non-interference by the state in religion. And by putting the word secularism in the Constitution, the constitutional mandate of reforming, especially Hinduism, for temple entry by Dalits might become complicated if secularism is understood in the Western sense. The third thing to notice is that, yes, 42nd Amendment was an authoritarian amendment brought in by an autocratic leader, Indira Gandhi. There's no doubt about that. And it had many authoritarian elements to it. What is interesting is that the 44th Amendment that the Janata Party enacted to repeal most of the 42nd Amendment retained the words socialist and secular, right? So even the amendment brought to undo much of Indira Gandhi's excesses, in retaining the little bit of the 42nd Amendment, is a sort of post facto endorsement of cross-partisan consensus about at least the part that was left behind, right? And it's a consensus not framed when they were put in, but a consensus given to these additions later in time by a different political coalition that refuses to remove these words, even as it undid so much else of the amendment. So that's not worth ignoring. Socialist is more complicated. Is more complicated because while most of the leaders of the assembly were socialist in orientation, in their politics, they did not want socialism in a particular understanding to be imposed by the Constitution. And what was that understanding they wanted to avoid? The Cold War is also just about to begin, right? And this is after the Second World War. And the two models of economic development, the capitalist and the socialist models, are becoming evidently clear in the world. The world is also dividing into the two power blocks, right? And the framers are already thinking about the path that India will pursue. And they're very clear that they want to allow the future governments, through the future people of India, to decide which path it should be, and also not to lay down any one path in stone. That governments and people of India should be able to switch. So this idea of mixed economy is to come around later. But what bits of socialism they did constitutionalize were the goals, and most of them are found in the preamble and in the constitutional directives, right? In part 4 of the Constitution. So India's Constitution requires the state to reduce inequalities of wealth, to ensure that the country's natural resources are shared equally. So equality, not just in the terms of non-discrimination, but actual substantive material equality, is a constitutional objective, right? And that part of socialism is fully embraced in the Constitution. The bit of socialism that the original Constitution does not embrace is the means of state control over the economy, right? That they don't forbid it either, by the way, right? So that question of how much of the market the state should control, how much of the market the state should regulate, and what is the role of private actors in the market, they leave entirely to politics, right? And this division between the goals and the means is quite important to appreciate the framework of the Indian Constitution. So I think that the best way to understand the term socialist added by Indira Gandhi in our Constitution has to be to understand it in that original sense of socialist goals of equality, of material equality, that the country cannot be vastly unequal, that the resources cannot be concentrated in the hands of one set of people, etc. While the means remain open for political debate and disagreement.
Just to add to what Tarun said, just small 2 points about reforming religion. If you look at some of these committees, advisory committees, you have a proposal by women members also saying that you have to be careful, because if you would notice, a lot of laws for women's rights were sort of brought during that time, be it the Sharda Marriage Act on child marriage. And the fear was that if we sort of use this word secular, which means state's complete non-interference, then what would happen to laws like these that have been brought? So that was one. And if you talk of the commitment to socialist ideals of not having inequality, of vast inequality between different groups, the commitment for this goes even before the Constituent Assembly. So if you look at Ambedkar's speeches in Bombay when he was part of the Provincial Assembly there, they're quite telling, and he talks of all the labor related laws that he brought during that time, maternity benefit, women in mines. So they, again, you get a very clear glimpse of that, this idea, if you understand socialism, that there should not be vast inequality and workers should be given social security and safety at workplace and certain rights at workplace. That was pretty much there even before coming of the Constitution, which then came in the directive principles. But yeah.
Thank you so much for this wonderful and very comprehensive explanation of both these terms. Moving on to your chapter on rule of law, I was particularly struck by this analogy from Alice in Wonderland, where you have used that Queen of Hearts used to declare punishment first and verdict later to explain how arbitrary power works. And also the way that you have described the distinction between rule by law and rule of law. So, can you explain the distinction between both these terms to our listeners? And how do you see similar tendencies like Queen of Hearts in present laws like UAP or preventive detentions law?
Sure. So the ideal of the rule of law, which I believe we translated as Kanun ka Sashan or Vidhi ka Sashan, is not simply the idea that the law permits whatever the government is doing. In fact, an idea that the government itself functions under law. An idea of subjecting state power to law, and it appreciates that laws themselves can violate the principle of the rule of law. That you can have a law that is not in compliance with the rule of law, which, I mean, given the terminology, it might seem weird, right? But once we appreciate what is the rule of law against, rule of law as opposed to rule of men. I mean, this is when the idea came up. There were hardly any women rulers, as it were. So that is what it is against, right? That government will be according to law. In law, which is predictable, which is stable, which is certain, which is something that allows you to regulate and govern your own life. So this is not an ideal that says laws should be good substantively, or that laws should respect rights. But law should be something that allows you to predict how the law will treat you. Right? So to just give one quick example, the taxman and the robber both take money from you, right? And they might take the same amount from you. But a rule of law compliant tax system would give you notice, would tell you how much will be taken from you, on what basis your tax is calculated, when you have to pay it, will give you the assurance that having paid, you will not be bothered for the next year, and so on, right? These are all things that allow you to plan your life. Whereas a mafia coming to do vasuli, or a robber just mugging you, does not give these other reassurances that, and therefore it doesn't allow you to plan your life. So that's the basic idea.
I think the second bit of your question about UAPA, certainly, and in the book we have talked about the recent example of recent threats to rule of law, and we talk of UAPA and laws similar to that, because effectively what happens is that by design UAPA and similar laws are that they're kind of like Rowlatt Act. You cannot appeal, you do not have many grounds of bail, and you're just sort of locked for a really long time. And we've seen in so many cases in recent past that is happening. Many known, unknown names charged under UAPA and have passed so many years in jail. So that clearly is the Alice in the Wonderland situation, that you punish someone first before the idea that process is punishment is sort of violation of rule of law. And that challenge is there in UAPA as well as in our criminal justice system overall, because the large majority of people who are in prisons are under trials, and so much so that there is a legislative acknowledgement in previously CRPC that if you've spent half of your prison term, if you were found guilty, then you have a ground of seeking bail and being released. So that is an acknowledgement that we have a systemic issue going on in terms of rule of law as far as criminal justice system is concerned, because effectively people are in prison before their guilt at all being determined. And I think laws like UAPA, the idea of rule of law is also the certainty that if I am operating within the boundary of what is legal, then I should not be arrested and my liberty should not be stopped. But how the words that are used in some of these laws are so broad that they cover even nonviolent action, giving a speech. A whole bunch of cases during anti-CAA protests were just based on giving a speech. Then you have uncertainty that how am I being charged in UAPA when all I did was give a speech? So that sort of uncertainty also creates a crisis of rule of law, I think. Yeah, thank you.
Just to connect this with my original response, laws which are vague, laws which are unclear, laws where the process takes a very long time, laws that are implemented unfairly, so not just based on who has breached it, but which party you vote for or which party you give chanda to. All of these things make the law more like the mafia, the robber, right? Because you don't have the certainty of where you stand with the law. Right? That sense of fear hanging over your head is always there. And I think that is what makes these laws particularly problematic from the rule of law angle.
Here we would like to wrap up the first part of this multi-parted podcast on this book. This book is just the beginning of what Professor Tarunabh and Surbhi believes is going to be a series where scholars are going to explore the Constitution in people's language and bringing the Constitution to the masses. So I hope the audience find it really enriching, and see you in the next episode of the same.
Thank you.
Thank you.